Starticus are in Belfast and we're delighted to be talking to the team at Tughans. Tughans is one of the largest leading commercial law firms in Northern Ireland and they've been operating here in the city for 121 years. Through a series of Starticus chats, we'll be talking about many of the legal fundamentals a startup will need to know as they grow and scale their business. We are joined by Adrian O'Connell, partner at Tughans. Adrian, thank you ever so much for joining us.
Good morning.
So Adrian, we're talking today about customer negotiations and I just wanted to check straight away, what do you mean by customer negotiations?
So this is essentially the negotiation that occurs between a supplier and a business customer. So I as a business want to trade with a customer and so I want to document that relationship.
Perfect. So you're in that process, where do you begin?
Well, again, you probably begin before your engagement with the customer. What you've got to do is understand that this is an art, it's not a science. There's no empirical way of trading with a customer. What you've got to do is have an approach which is both responsive and understanding of the customer. The first point of departure is got to be to ask yourself two questions. Look, why are we contracting? And secondly, have we got the value proposition right? An imbalanced relationship is not going to work. The longer your relationship with your customer, the more important that second question has got to be to you. The challenge has always got to be to plan and document. So you've got to meet the regulatory, operational, financial and tax requirements of the relationship. More importantly, you've got to meet its commercial objective for both parties. The balance that I find in those relationships is between control and reward. Reward has brought you to the table, but there may be an element of sacrifice in terms of control to achieve that reward. So that's the first phase for me. That's how you begin, and that's in the planning and then you move on to the execution. Perfect.
So in terms of obviously where the heads of your terms of business come in, what does someone need to have in place to make that a proper contract?
Yes. Well, there's no requirement to have heads of terms. However, heads of terms can be very useful. The usual sequence in a larger transaction is that there be a heads of terms followed by the formal legal document. Now, the heads of terms themselves can be either non-binding to free up discussion or binding, legally binding, and you've got to make that decision. But I do find that the heads of terms can be underestimated because in my mind, they are a good chance to get thinking before. They good chance to consider what's the commercial focus of the discussion. Secondly, are we making sure that we're not shutting the door on any points that are of important to us? And thirdly, God forbid, maybe even extract some concessions before the lawyers get involved. So my advice on heads is don't underestimate them. They set the tone of the deal.
Perfect. Let's just take a step back really quickly on that. So heads of terms, just give us a definition of what that means for someone who maybe doesn't know what that means.
That will be extracting out the key commercial points in your relationship with your customer, your business customer, and trying to isolate those and put them down on paper before you have to get lost in the legal forest of provisions and boilerplates.
Okay, so there's not a template as such, but give us some of the things that should be really included in that.
Well, these are exactly what we come on to next, be it the heads, be it the actual formal legal contract. That's got to cover key deal terms. And what are those key deal terms? Well, they're, in my mind, for any contract, there's about a dozen of them. For this purpose, I'll pick out 4. The first would be in and around whether exclusivity is on the table. Secondly, around payment, always important. Thirdly, about limitation of liability, and fourthly, about termination. So taking those in turn then, when we're looking at exclusivity, is there scope to ask the customer for exclusivity? And what does that look like? How is it defined? Is it by territory, time, product, sector? Because you can cut exclusivity many ways. Exclusivity is important in that there may be a price that's paid for it. That may be a minimum purchase obligation. It may be an upfront fee. Indeed, it may even be a non-compete restriction that the customer is prepared to give you. So what you're trying to do with exclusivity is, bind in the customer and make it worth his while at the same time to do business with you.
And would that be on price, or how are you gonna get to that point where you've got that exclusivity? Is it price?
Well, as I say, there could be a premium paid for it. It
Yeah.
could be on a discount on the price. Equally, it could be on a non-compete restriction, or it could be on a minimum purchase obligation.
Yeah.
Those are the quid pro quos for the supplier. On the customer side, he'll be focused in on the price, though.
Yeah, always the price.
Yeah. So then the second key deal term that I would be looking for is in terms of payment. How, essentially for the supplier, how quickly can they realize the revenue? Now, the payment profile is obviously going to set the amount and when it's paid and on what payment terms. So, the more you can upfront that, the more you can front load that, the better for the supplier. Now, in terms of the payment terms, we're trying to get cash realized as quickly as possible. So there may even be an element of underwriting that with an insurance product, be it credit insurance or indeed a letter of credit. But we're trying to realize for our business and cash flow the revenue under this contract as quickly as possible. The other aspect to it is whether the pricing is fixed or whether there's scope to review it. Now, a review is obviously favours the supplier because he can then get in and understand whether there are certain risks that he can mitigate. So that price review can happen because a date milestone has occurred.
Yeah.
Equally, it could happen because an event milestone has occurred, such as a rise in the supplier's costs.
Yeah. So obviously, let's think specifically about tech businesses here. Is there anything else in obviously the terms that would be specific to tech business, or how is that?
I certainly can. Let me just finish on the
yeah.
termination and the limitation of liability, because these are more generic to all contracts.
Okay.
And then we can. Yeah. There are certainly key deal terms which are specific to the technology setting. But in terms of limitation of liability, look, if you don't have a limitation of liability, your liability is unlimited. That is not attractive for any supplier. So what you've got to be thinking about is there scope to cap my liability here? How do I pitch that? Is it a percentage of the contract value, or is it a specific figure? So you take that away and you consider that, because as I say, if you have not capped your liability is unlimited, and that is never attractive. So then you would be looking at setting that figure and understanding that it needs to be reasonable, otherwise it will not be enforceable. So it's got to be a reasonable figure. It can't be £1. Usually people pitch it at something relative to contract value, and then they would also marry it or tie it into an exclusion of consequential loss. Again, attractive for a supplier to make sure that he's not on the hook for any indirect or consequential loss. Finishing then on the key deal terms, termination. So this is tied to duration. You've got a contractual relationship that's going to time out, but is there any scope to terminate that earlier? That could be if the customer is not about because of an insolvency event. Equally, it could be through breach or default by either party. There are other termination triggers that you might want to consider, such as change of ownership or control. If the customer was no longer the same person that you set out dealing with, is that enough to make you want to change path, change course? And also then customers may look for without cause termination, an ability for them to walk away or break earlier. And if that is something that you're prepared to consider, what's the quid pro quo? What's the premium that's to be paid for that? Because that gives the supplier a tie-in, and it gives the customer an awful lot of flexibility. So there's got to be a premium for that. Then coming back to exactly what you asked for, what's specific to the technology setting? Well, the perennial issue is whether the IP is licensed or whether it's transferred. Do we transfer ownership of the IP, or do we only license it? And there's many factors that could inform that discussion, particularly around who came up with the idea. Was it the customer? That may give him a better argument for ownership. Indeed, is the technology very bespoke to the customer? Again, another argument that the customer may want to own. But for a supplier, he'll want to license it, so he'll reserve his position. He'll keep back ownership so that he can maybe go into play again with other customers. And if you are licensing, then your considerations are: what's the scope and extent of license? Is it an exclusive license or a non-exclusive license? In terms of use, is it simply use, or can the customer go on and modify and sub-license? So you'll be thinking about those issues. And then in the technology setting, dealing with the customer may want you to stand over your IP. The normal form that takes is in an IP indemnity setting. So you'll be asked for an IP infringement indemnity, and you've got to have figured your position out on that before you go in. Are you prepared to stand over your IP? How comfortable are you, or what comforts can you take with the IP being out there and known?
And I think obviously listening to you now speak about, obviously it's key to not just understand it, but get advice, legal advice, one assumes, because these are the type of things that most people in business wouldn't have the knowledge to fine tune themselves.
Very much so, and indeed, so often people come in to me with a contract that they didn't take advice on, that they signed, and then they want to unpick. That's a very difficult exercise. It becomes more of a risk analysis rather than an advisory exercise that you're involved in. So oftentimes that's too late. And with contracts, you've got to anticipate as much as possible, as early as possible. And just feeding into what you say, it may involve effort, including legal effort up front, but that is an investment that should pay off through the life of the contract.
It's obviously better to pay at the start than obviously 12 months down the line, and then you're looking at it retrospectively and you've got a problem on your hands.
Correct.
Okay, great stuff. Adrian, pleasure to chat with you today.
Thank you.
Thank you so much for your time.
Cheers now.
Thank you.